prosecutors, you wanted to speak with me?
Sure.
Okay.
These are just audio recording devices, that's all.
Okay. Well, you asked for this meeting, so I'm going to let you speak. The goal of any meeting like this is to try to reach some sort of resolution on this case. So I think you asked for about 5 minutes. Obviously, I have no desire to get into a 2-hour conversation here if we're not going anywhere. I don't think you do either, though.
I'm not, and I never need to make arguments or any claims or accusations or any logical fallacies, including ad hominems, and I'm not here to cause any kind of a disruption or problem to anybody. Couple of issues. The first one is, I just want an acknowledgement of a few things that the judge has done. Now, I'm not giving blame whatsoever to the prosecutor's office for what the judge has done, but I have a follow-up question that's very relevant and important, which is where I'm going. So what we've seen this judge do so far, and this case is over a year old, since July 22nd, is I was given a court date when the address and contact information was knowingly unknown and uncertain. And I was requesting to be emailed, and I was requesting to be called or texted, and none of that occurred, and something was sent out in mail, which I told the court wouldn't reach me. It didn't, and then I missed a court date that I didn't know about in October of last year. So then a bench warrant was issued. That has been resolved. Just to acknowledge that that is in the history. On July 16th, I was scheduled for a hearing here that I told the judge was 4.5 hours prior to a hearing I was scheduled over in St. Charles County. And he, while smiling, repeated that he was giving me this date. 3 times he did, because I thought he had misheard me. He did not. He was doing it on purpose. I came here at the 9 a.m. showtime, my bench trial, which, by the way, I would never allow. I would only trust a jury, not a... And if they don't do those here, then it's trial de novo time, so I can get into the county for a jury. But regardless, when I gave him permission to rule in my absence, because I had to leave at 10:15 to go to the next trial, he ignored that and issued a warrant for my arrest for a charge of failure to appear, even though I had been in this very building for 1 hour and 15 minutes. When I had to leave to go to the next hearing, that follow-up judge discovered this arrest warrant mid-hearing, and he made a phone call back here because he knew. He asked me what had happened. I told him, if that says failure to appear, that's not true because I was there. If they have rules about you have to sit there and listen, whatever, that was never presented to me. And this judge verified that I was to be arrested. And I was, and I would still be in that prison right now if I did not have another $500 to post out. That brings my grand running total to this county to $3,000 just to stay out of jail while presumed innocent. $500 is a max penalty fine for the 2 charges that I'm facing. So the max penalty has already been paid. And I had 2 arrest warrants on this, very minor of traffic tickets. A non-moving violation, obviously.
Well, the no insurance ticket is not a non-moving
violation. Then I stand corrected, and I will defer to your definition. I'm not needing to contend.
It's Missouri's definition.
I agree it is. Okay. I'm not contending this, so I'm just stating, because again, the follow-up question is coming very quickly. So I've not arrested from that. Now I get out of that. And now I'm sent to the other judge here, which is a complete waste of time. She does the exact same tactics. And this is what I want to finally bring up, and then I'll ask a question, which is the tactics in this office, despite me needing just a simple yes or no clarification of the judge, are to not say words that challenge what I'm trying to get clarified. They don't use statutes or anything of authority to contend what I'm saying. What is done instead is a silencing of me through a chilling effect of the coercive threats of violence of being held in contempt and thrown in jail. I don't ask anybody to believe this or my opinions because it's all on the record, and if this court isn't actually recording through there, every of these hearings has been recorded. I record all audio hearings because they happen in public. And if they want to charge and arrest me for that, they are welcome to try. So, again, I have evidence of all of this. My question to you, sir, under the prosecutor's office, that I think a lot of people will be interested to know, is all of these actions have occurred in full view of the prosecutor's office. What would have to occur? What would the judge have to do in order for the prosecutor's office to step in with whatever duty it believes it has to correct a judge that is making, let's just say, inappropriate to illegal activities? It's a hypothetical question about the line drawn. Now, obviously, if a judge says, hey, just for no reason, taser him right now, I would hope that the police and the prosecutor would say, we're not going to do that. So I'm just trying to find out, according to this prosecutor's office, where is the line between where a prosecutor has to step in because of due process violations or false imprisonment and charges that aren't true? Where is the line, sir? That's my question.
So, to answer that question, and then there are some things that you've talked about that I made notes on that I do want to kind of just comment on as well. So, my answer to this kind of goes back to one of your initial points here. The prosecutor's office and the judge's office are completely separate, and obviously for a reason. So, I understand you have concerns with the way the judges handle this matter. I have no control over how the judge runs his court. The judge's role is to execute the laws, to execute the role of the court, and execute judgments and determine fact. So it's my role as a prosecutor to put on fact, to prove the case, and you have the opportunity to dispute that. Now, you left before you had the opportunity to put on a defense when we had the trial. So the trial was not concluded. We were set up for a trial. You left prior to the conclusion of the trial, so that's why the failure to appear was issued. But again, I have no control over how the judge operates. Now, yes, if the judge says, let's tase this gentleman, and you're sitting there, then I would speak up and say, I don't think that's appropriate. I also don't think that the judge is going to say something like that. I've known this judge well enough, and I know that he understands the way these courts operate. So my role and his role are completely separate. It's not my role to tell the judge how to run his court and what decisions to make. So it's not my position to speak up to say the judge is not following the rule of the law. If I put on my evidence and the judge can interpret and can find the facts the way he views them.
So what you've stated so far is your role. You stated that the prosecutor's office would intervene if a tasing attempt happened, but you haven't interfered yet with a imprisonment with for 4 or 5 months now. I've been trying to invoke state Missouri law to get this judge to recuse himself in accordance with guidance that's printed right there on the wall. I've filed a motion. I've made multiple requests in person during the court. He will not hear them. He will not understand. So you're witnessing a judge who is defying state law that says that all other authority under this, whatever it may be, is null and void compared to this guidance here. So I understand the jurisdictional shell game where lower courts can say, oh no, we have a rule this or a rule that. Like, oh no, you can't record an audio in public place here because we say this reason here, right? But my point, that's clear-cut law. I've used it over in the St. Charles County, and it happened like that. No problem. I'll recuse myself because the law says you don't even have to have a reason I agree with. You just get to do it once. I've been trying to do that this whole time because on the record, in the court of public opinion, this judge, and in accordance with what's on paper, has violated due process like in a million ways, and I don't need to contend that, but there's the law. He's openly defied it, and this office has done nothing.
If there is a violation of the law, though, you've stated yourself, that's a state law, correct?
It's all your guys' law. It's not mine. I don't rely on this authority.
I'm the city of OFallon municipal prosecuting attorney. prosecute municipal ordinance violations. So if there is a state law stating that a judge has to do act a certain way or offer certain things, that is a state violation. I don't have the authority to do anything on that anyway. That's something you would need to contact the appropriate authority to pursue that matter.
That's a fair enough answer.
That's outside of my authority to do anything on that.
Fair enough, but stopping a tasing is within your authority.
If there's going to be an active assault, then yes,
so
I would have.
Taking somebody into custody on a charge of failure to appear when they did appear, that's an imprisonment. That doesn't qualify?
Well,
but a tasing does?
The warrant issued, you were given the opportunity to bond out, which you did. Now, and that kind of brings me to that bond issue that you mentioned as far as what you've paid them. Just because you have paid this amount of money does not mean that that goes towards those fines, does not mean that the city of OFallon keeps that. That bond is there to secure your appearance. So when these cases are resolved, they can either be applied toward any fines or that would be returned to you. So just because you've paid that doesn't mean that the court has taken that $3,000 and it's never to be seen again. That is there to secure your appearance on the case. Now, you do also have the opportunity to request a trial de novo, and you can send this to the St. Charles County Court and have a new judge. To that point, I will mention, though, that as you stated, the range of punishment on these charges is up to a $500 fine. The Supreme Court and courts have enforced and determined that unless the level of the offense rises to a range of punishment exceeding 6 months, it does not entitle you to a jury trial. So while you may be entitled to a jury trial, it's based upon the rules of misdemeanor courts within the states. And if this does not rise to an offense that has a range of punishment over 6 months, a jury trial is not authorized or guaranteed. So you can request a trial and you can request a new judge, and Judge Burns in the county is happy to hear this case.
Okay. What about the Missouri state law that says you get to have a judge recuse themselves? You're saying that's not your job, but it should be theirs?
It would be your, if you feel like there is a state law that he is not following, it would be your responsibility.
It's not my feelings, it's posted on the wall.
Right.
So feelings has nothing to do with it.
It's your interpretation of this that he's violating that. So you would need to contact the state and the county, St. Charles County Prosecutor's Office, to inform them of this violation. I'm not saying. I'm just letting you know. I'm going to make a commentary video about this, and every time you defer blame and use language like this is somehow my fault, I'm going to make fun of you for doing it. I'm not saying it's. I'm just saying I'm the city of OFallon municipal prosecuting attorney. I cannot bring a state charge against anyone.
I know your time is limited, so it's in both our benefit for me to interrupt and say this. The only answers that you're giving me are answers that I already know, because you're just stating standard procedure and what normally goes on here. I didn't come here to be educated about that. I already know all information you can just find online, plus the assistance of artificial intelligence. I am thoroughly familiar with stated policies. I do not rely upon the authority or power of stated policies. And I know you know this. I rely on the public and political pressure that is generated in the court of public opinion through social media. Okay, so everyone understands that prosecutors have your rules and you're going to go by them. I'm not contending that. That's fine. All I'm doing is clarifying the prosecutor's position. You have said so far you would intervene if the judge attempted to tase you. You've shown so far that you won't intervene if they attempt to imprison. And now you've given the reason, well, it was because you showed up at the trial and then you left early. You're basically, despite saying that the prosecutor's office and the judge's office is separate, which any average John Q. paying member of the tax would laugh at you for. That's completely hilarious to think that there's not a conflict of interest when both parties are licensed and paid by the same fictional entity known as the authority of the state of Missouri, okay? Everybody knows you all work together and talk together. It's a de facto collusion. In actual reality, this is what I'm talking about. I don't expect need you to respond because you're just going to deny it. But my point is, again, we're clarifying where your prosecutor's office is going to intervene and not. So what I've to understand so far, you are claiming independence, but you adopt the positions that the court does. You do not agree that I showed up, began to participate in the trial on the 16th that was against my will, where you know I have not been allowed assistance of counsel. He's not even asked my income or if I would qualify for a public defender. He wants nothing to do with the assistance of counsel issue. And he won't allow me to bring that up either, okay? When I ask for a jury, he won't allow that at all. Now you have your rules, and I understand you have your rules, and it's all written down, and good for you, you have all the rules. But the American public is not going to think that a person does not have a right to a jury, that they must be heard by the same judge that on the record is exhibiting such heinously, blatantly abuses of power through the violations of due process, through coercive threats of violence, by demanding that I remain silent and not bring up these issues in court. And then, in order to end the hearing, he will, through his assistant, shove a yellow receipt paper in my face that has the next court date already on it, and he'll call the name of the next person in line, knowing that if I said, well, I'm not done yet, I still have court business to conclude here, that he can have me arrested on the spot because I'm then disrupting court proceedings. And then, what's even worse, is they go into the record, and because it's not recorded, and they don't allow me to record it formally, even during my trial at audio only, when no one else was in the room other than government employees, which is 1984 creepy as heck. Okay, all of these abuses of power are going on, and I'm just summarizing it all in one place. Okay. I think it's wise if we just cut to the chase. I've said everything, and everyone knows your opinion already. The prosecutor's office is not going to do anything, even seeing all of these violations. Would you contend that of all the acts that are currently on the record that have nothing to do with my opinion, would you contend that the prosecutor has in fact done something or has not done anything because they're not allowed to?
Well, a couple things that I would say here.
If you could just be responsive to my question first and then go off to side rail, that'd be great.
No, I will be responsive to that question, and hopefully you've noticed I'm taking notes here so that I can respond to your questions. First of all, I'm not adopting the position of the court. And again, my role is to enforce the laws of the city of OFallon. If I
You're
see
not
that the
being
judge,
responsive to
I'm
my
being
question.
responsive right now.
You're not. I asked a specific question, and you're giving a side branch story that has nothing to do with it. I simply asked you, sir, with respect, I asked you specifically, do you contend with the claim that the prosecutor's office, up until this point, has done absolutely nothing to interfere with the conduct of this judge according to the record? That's a yes or no.
Do I contend that I have done nothing to interfere with what the judge has done?
I believe the prosecutor's office has done nothing. Do you contend, do you challenge that claim?
I would agree with that. And that is because I do not believe that he has gone outside of his realm of authority in his role.
That's a fair answer, and it answers my question completely.
Absolutely. I'm happy to have this conversation with you. And if I could make a couple other points here. You've mentioned that we follow standard procedures. And I'm just curious, is a court to treat different individuals differently? My understanding is there is a set of rules that applies to everyone equally and fairly. If those rules do not apply to everyone equally and fairly, then we have a miscarriage of justice. But you say that we follow a set of standard procedures like it's a bad thing. My understanding is by the court following and the prosecutor's office following these standard procedures, that's carrying forward the opportunity for justice to all individuals on an equal basis, because we can't treat different individuals differently.
I'm not making any claims in this regard whatsoever. I'm curious as to the foundational. You claim that you understand there are rules that everybody has to go by. Upon what factual evidence do you use where do you get these rules? I would love to know, where are these rules that you're saying, these rules that everybody has to abide by, where are they?
You're talking about the ordinances for the city of OFallon?
I'm talking about whatever you're talking about.
So the city of OFallon has ordinances, the state has statutes, so those are the rules and the laws that anyone within the city or within the state is required to abide by. And if they do not, then that's how we get to this point, and then the evidence is shown to the judge, and the judge can make a determination based upon the facts presented at the case whether a violation of those ordinances in this situation has occurred.
Again, when you wander into standard procedure, you're just kind of preaching your own case. You're not informing me of anything. I'm trying to let you know this so you don't waste the time. I already know standard procedure. I'm here to discover what you're doing in regards to it. When you say, hey, my foundation to make this claim that I believe in is based on statutes and laws. What good does it do to offer something so vague?
Air quotes for statutes and laws? That's one thing
It's
your recording doesn't pick up. You said statutes and laws, but you did air quote
Yes,
around
I did.
that as if statutes and laws are not a real thing.
No, that has nothing to do with their reality. It has everything to do with your claims about their validity. Now, you say statutes and laws. I use the quotes to show that your answer was vague. And when an answer is vague, it's no answer at all. I asked for a specific answer. Upon what factual evidence do you rely to form the conclusion, this vague conclusion that there are laws that everybody has to abide by? What laws do you refer to? If you answer the statutes and codes, that's an answer. Is that your answer?
That's the ordinances for the city, and then the statutes within the state of Missouri are the laws that individuals are required to abide by.
Great. Are you aware of the main question and clarification that I have asked of this judge from day one, literally, the first words out of my mouth up until this time? Are you aware of the main yes or no clarification I've asked of the judge?
Would you like to tell me?
I will. As soon as you tell me if you're aware of it or not.
For the sake of this conversation, let's say no.
But you are. But for the sake of the conversation, no.
I'm giving you an opportunity to tell me.
Well, either you're aware of it or you're not.
What does it matter whether I'm aware of it or not? You have the opportunity to make me aware of it.
I'll tell you
right
exactly
now.
why it matters. It matters because you're the main prosecutor in this case. This case has been going on since last year, July 22nd. And I've written how many? 6 or 7 motions. And if you're not familiar with the main part of my case, you're not familiar with any part of my case, because that's the only main part of my case. If you're not, that's fine. I'm not trying to insult you. I'm just coming to a fact that you either are or not familiar with the main clarification, because I state it over and over and over every time I'm in a hearing with the judge. So I think you are aware of it. If you are, please say so. If you're not, please say that.
I understand you're asking me a question. Here's what I'm going to say. We've been talking for quite a while now.
So you're going to escape? You're not going to answer by running away, really?
My understanding is your concern is you don't believe the city of OFallon has the power to
I do
these ordinances.
Not. You're making a claim about me. I don't believe it all. That's not true at all.
Is that not your main
It's
concern
not
with
my
this?
main concern
Your
at
main
all.
concern
It's
pertaining
not
to the
at all.
judge.
Which is why I asked, so we can clarify mine. Because here it is, and then we can get out of here, okay? Because this is the end. I am only ever clarifying the claims of the prosecutor's office and the judge. If I were to ever make a claim, as you well know, I would assume a presumed burden of proof. I don't want this burden, and I don't need this burden. Therefore, I don't make any claims or arguments. Now, this is the main tactic of every prosecutor and judge I've ever come across, is they accuse you of making arguments so that they know how to deal with that. It's like, oh, well, now you have the burden of proof, and you can't prove, therefore I can dismiss. I purposefully do not assume the burden of proof. I don't make any claims. I don't need to. So the clarification is like this. Judges will claim you're presumed innocent, correct?
Yes.
Yes, they will presume you're innocent. Will they presume you innocent of every element, or do they presume you innocent of some but guilty of others?
You are presumed innocent until proven guilty of the offense. That includes every element underneath that offense.
Is jurisdiction one of those elements?
Yes, it is.
So would you naturally be able to conclude then that I am presumed innocent of jurisdiction?
Until proven otherwise. And that's part of the matter that's proven at trial. One of the first questions is, where did this offense occur? Did it occur within the city of OFallon, which was located within the St. Charles County in the state of Missouri? So that's one of the first elements that's deduced at trial.
What you just did was the number one tactic that judges and prosecutors use, which is a deflection by using a definition. Please allow me to finish. An alternate definition of jurisdiction, because jurisdiction does have many definitions. You use a geographical-based definition of jurisdiction when you, or no, I don't want to say, where I am letting you know that I am not talking about that form of jurisdiction. I am talking about the right to impose. Your claims to, it's within this certain maps and everything, that's according to statutes and codes. It's by authority of your statute that everything you're talking about with geographical location matters. So before that, there's a root, and it's the root that I'm pointing at, not this side branch, okay? So the court will say that you're presumed innocent of every element. That jurisdiction is one of those elements that you're presumed innocent of, and therefore you are presumed innocent of jurisdiction. I've done this for 10 years in front of dozens of judges. They will all admit that, especially when pushed through the pressure of public opinion. And so, if I and all of these people are presumed innocent of jurisdiction, I'm simply asking for the mechanism by which that gets flipped. Because I very much am imposed upon. There are coercive threats of violence and bench warrant arrests that are constantly being used systemically, everyone knows. And they use the silence that happens because of the coercion to imply on record that they don't make that the defendant was voluntarily doing what the court is recording. That is not at all what happens. The defendant is threatened, made silent, the judge writes whatever truth he wants recorded, and then in future hearings, that is what is believed to be true by any judge, because it's in the system. Okay, so I have always asked of the prosecutor's office, because it's the prosecutor's job to file a proper case, not the judge's. I've asked, Judge, I don't even want to pick a bone with you. I don't even want to fight with you or talk to you. My clarification is for the prosecutor. Now, fortunately, you prosecutors aren't even here most of the time because you can just do that and get away with it. That's fine. But I would like to know, and that's the heart of this meeting, if judges, when pressed, will admit that people are presumed innocent of the elements and jurisdiction is an element and it's the right to impose, then what does the prosecutor file provide to the court that in regards to that matter whatsoever? If it's a nonsense point that I'm making, why do military courts do it with the UCMJ and a signature? Why do all religious courts of religions? I grew up Mormon. They have courts. Jews have courts. A lot of Christian courts. They all have jurisdictional matter. If you don't want to be there, you don't want to consent. I don't want to be a member anymore. Or, hey, I consented because I signed the dotted line of the military. International courts, human rights violations. They all address the jurisdictional issue. These systems don't do it with nonviolent victimless criminal charges because this is all just legalized extortion, so the people say, not me. Has your prosecutor's office provided any document whatsoever? Not what is in it, not is it worthy, not I want to judge it. That's not it at all. My one clarification of this entire case from day one is, has documentation passed between your office and the court regarding this element of jurisdiction? And the answer is no, nothing's passed, as far as I can tell, because I haven't had a judge give me an answer on that. He refuses to. I'm still 15 months later trying to get an answer to that. If he answers no, well then, case dismissed, because you don't have jurisdiction, say you, and he hasn't provided, therefore I'm going to motion to dismiss all charges, and because you don't have any opposition to give, it's an unopposed motion. Any fair, independent, and impartial judge, which all judges aren't, would grant unopposed motions. This judge doesn't. He says, I don't have to. There's no oversight whatsoever. I've called and made complaints starting almost a year ago with the judicial board in Missouri that does that. They don't even respond. I've filed 3. They don't respond to complaints at all. It's 9 months old, not a single peep from them. Or the other follow-up. Now I'm having to go to the Attorney General's office. All right, because I am going to get the trial to novo and get to the jury. And all of this is going to get out on social media. And I know you guys all believe that you can keep it all small and hidden, and I'm just some nobody, and it's never going to. Well, I guess we'll just see what happens with social media when it comes to that. So, to wrap it all up, have you provided any factual evidence to the court regarding the element of jurisdiction as part of the properly filed case as of this moment in time? Yes or no?
Yes.
Thank you. Oh my gosh, I so rarely get a yes. Thank you for the yes. Is there anything, is it one thing or 2 things or 3 things?
I think our definition of jurisdiction is going to differ. So
I'm talking about the right to impose.
No, I think our definition of jurisdiction is going to differ. So
if you're going to use a legal definition, then that's all the answer I need to hear, because my listeners already know the answer you're going to give if you're going to give a legal definition that says it all has to do with geographical boundary and nothing to do with the right to impose upon people.
The role of the courts is to enforce the laws of the city and of the state. So yes, obviously my definition to jurisdiction is going to be a legal definition.
There are several definitions to jurisdiction. All courts and all judges throughout American jurisprudence have used the definition that I'm talking about. Don't disvalidate a definition of jurisdiction that means the right to impose.
The legal
I'm not disvalidating it at all. I think it's perfectly legal and valid. It just doesn't apply here. And you know that it doesn't apply here, but as part of the trick the lawyer uses is, it's like the word has 4 different meanings. And I'm pointing at this one definition. And you're saying, I don't agree that definition exists. I think it's this one over here. Okay.
Mr. Pierce, I think that we've had an extensive conversation here. I've given you plenty of opportunity to express your view on this.
Yeah.
Hopefully, you feel that I have.
Well, you said that you had provided anything, but what was it that you provided?
The information is provided to the court on the citation stating where the offense occurred and what the offense is and who the individual was that committed the offense. That's the information that we provided.
Outstanding.
This conversation, Mr. Pierce, is over.
Is there any other piece of information, or is it just the one?
Once the information is filed and the case is set for a trial, it is now the prosecutor's role to put on the facts and the evidence
You're
of
not
the case.
answering the question, sir.
I have answered your question.
Great.
I have answered every question you've asked
that
me,
all
sir.
it is?
This conversation is over.
Is that all it is, or is there something else that you're using for
I believe
jurisdiction?
we're set for a trial in October.
Why don't you answer if there's something
Sir, I've
else?
answered every question that you've answered here.
Except the
every
one I'm
question
asking
you have
now.
asked. No, I've already answered that. I let you know
Is
every
it the
piece
only
of
thing we're
everything that we
using?
provided.
Just say it's the only thing we're using. That's all you gotta say.
I have answered all of your questions.
Why can't
I've
you say
allowed you
that?
to record this
Do
conversation.
you see how creepy that sounds when you won't answer a yes or no? Why don't you answer if there's anything else you're using besides the ticket?
The ticket is the information that is provided to the court with the factual basis for the case.
Are you using anything else?
Anything else is provided at a trial.
I'm not
Any
talking
other
about
evidence
proof toward my guilt. I'm talking about regarding the element of jurisdiction. You said you're using the ticket. I said, great. Is there anything else you're using?
The ticket is what's provided.
Are you using anything else? Because when the
Sir,
public shoots down the ticket,
we're done.
when the public shoots down the ticket reason, because it doesn't say the word jurisdiction on it,
I
then you're
tried-
going to say, oh no, it was this reason over here. It was this reason
Pierce,
over here.
I didn't
I'm
want
trying
to stand
to
up and
isolate
walk out
your
on this
reason.
conversation, but I've told you many
You're
times.
doing what all judges
this
do.
conversation
Goodbye.
is done.
Goodbye. I'll dismiss you. Goodbye.
Thank you, sir.
Goodbye.
Have a great day.
Enjoy your career being a legalized extortion artist, predating upon vulnerable
Sir,
and weak people.
You can leave now.
I don't know how you look yourself in the mirror.
Can you do
Security. Security. I'm leaving. Don't worry. I'm leaving. I'm leaving. I know when the line is crossed and when you start calling out actual truth like that, the cowards that they are use armed people with paychecks to solve their problems instead of solving the problems that they start. It's in this building only that fool has power.